Good morning and welcome to the Utah Court of Appeals. I'm Judge Ryan Harris, and with me are Judges John Luthie and Amy Oliver, and we're happy to be here to entertain your arguments today. Our second case on our calendar today is State v. Haynes. The case number is 20220420. If I could ask the attorneys who are appearing on that case to state their appearances for the record, please.
Andrea Garland on behalf of Mr. Haynes.
Morning, Ms. Garland.
Michael Gadd for the state of Utah.
Morning, Mr. Gadd. We're pleased to have you both here in front of us this morning. Any questions about the procedure before we begin? Looks like we've got 3 minutes for rebuttal. Is that right?
That's correct, Your Honor.
Okay, well, without further ado, Ms. Garland, we'll turn the time over to you, and we look forward to hearing your argument.
May it please the court, Andrea Garland on behalf of Jimmy Haynes. We want to address bolstering, prosecutorial misconduct, destruction of evidence, and the rest as time permits. We're not necessarily going to be reaching every error in every category. The first category is bolstering, which came in through different witnesses. The state has conceded error where the complainant testified that her sister-in-law believed her allegations. This was prejudicial because these convictions lacked physical evidence, confession, or third-party eyewitnesses to the crime, which our Supreme Court and this court has said makes it not strongly supported by the record. And even the state said in both trial and on appeal that this is a credibility-dependent case, making errors more prejudicial, and that another family member, knowing both Haynes and complainant, believed complainant, was prejudicial. This is one of several bolstering incidents, the most important of which I think was actually where trial counsel failed to object to mother testifying that she believed that the complainant's allegations were true. The state's argument in trial was this really happened because mother believed that it happened, and it really happened. Trial counsel could not therefore have reasonably thought that this was some purpose-based exception to Rule 608A. Rule 608A bars direct testimony.
Well, didn't that particular piece of evidence help explain some of the actions that some of the actors took throughout the course of events?
Well, the state understood it in trial as bolstering, saying this really happened because mother believed that it happened, but Rule 608A bars direct testimony about the truthfulness of a witness on a particular occasion, and there isn't a purpose-based exception, and narrative purpose does not place evidence outside the reach of evidence rules. So it was deficient and prejudicial to not object to this testimony.
So as I understand it, the evidence came in that mother didn't believe her initially, and that's why she ended up, at least part of the reason why the complaining witness ended up moving back to California, left the home here in Utah, moved back to California, and there was some other testimony about contact with family members and why weren't you contacting family members? Well, because some of them didn't believe me and there was friction and it tore the family apart. And, you know, in terms of it being part of the narrative to explain how the story unfolded, that isn't something you think plays any role under 608?
Well, no, it's still direct testimony about the credibility of the witness. And this testimony came in first. Mother testified that she hadn't wanted to believe these allegations, and then the state directly asked her, well, did you change your mind about whether the complainant was telling the truth? And she did. She said yes, she did, and then she explained that she believed the complainant was telling the truth and why. And then she later testified, too, that she not only believed the complainant was telling the truth, but she did so based on her expression and her own experience with Haynes. And this was precisely what Rule 608A bars from evidence, and the state used it as bolstering testimony, arguing in closing that that's why the jury should find complainant credible. And the prosecution's emphasis shows that the state considered it as important bolstering testimony, and it was important bolstering testimony. And that's especially true in a credibility-dependent case.
Would the state have been allowed, for narrative purposes, to just ask maybe the less pointed question, but at some point, did you end up confronting Haynes about this? Would that have been permissible?
That particular question, asking a yes or no question, I think that might have been permissible, but that's not what we had here. Instead, we had multiple incidents of saying she believed the complainant, and then multiple witnesses saying we believe the complainant. This was prejudicial both individually and then cumulatively in light of the evidence that the prosecution later denigrated other evidence, and it accumulated with the lack of 23B evidence from others in the family and the household. This was a number of people saying believe the complainant, and as such it was both deficient and prejudicial to not object. My next issue is failing to object to prosecutorial misconduct at rebuttal was both deficient and prejudicial. It was ineffective to not object to misstatements of law when the prosecutor claimed that evidence rules prevented her from proving her case, saying we had to follow the rules of evidence. The state doesn't even dispute that the prosecution misstated the rules of privilege and hearsay in her closing argument. This court has said that remarks are so objectionable as to merit reversal when they call jurors' attention to matters they're not justified in considering, and this court has said that misstating law in closing arguments necessarily calls the jurors' attention to matters that they're not justified in considering. This was deficient because these remarks were so objectionable that as to merit reversal, and it was particularly prejudicial because they unfairly portrayed the defense's reasonable doubt argument as trying to benefit from the state's unwillingness to violate the law. It portrayed the argument about proof beyond a reasonable doubt as a disingenuous ploy. This was not a fair response to the defendant's argument, and remarks are more apt to be prejudicial in cases where the conviction is not strongly supported by the record, as we have here. This happened on rebuttal, so the defense could not address the impact and thereby ameliorate it, and there were no curative instructions. Additionally, the prosecution saying there was zero evidence of recantation, that was deficient to not object because this exceeded ordinary spinning. It denigrated evidence of recantation to gossip, and then the state doubled down saying no one said this, and it asked the jury to consider matters not in evidence. This was particularly prejudicial because it went to the heart of what the case was about, whether this happened. It portrayed exculpatory evidence as non-existent and the reference to it as a bad faith ploy. It was also ineffective.
How do you account for the U.S. Supreme Court statement in Donnelly about the U.S. Supreme Court statement in Donnelly that in closing arguments, quote, improvisation frequently results in syntax left imperfect and meaning less than crystal clear. And the state's argument based on that the jury would have reasonably understood that the prosecutor didn't mean truly there was zero evidence, but that there was no good evidence. The prosecutor had just addressed the evidence that there was and shown why the prosecutor believed it shouldn't be believed.
If this had been an ambiguous statement, I think that could be a point, but zero is unambiguous, and then where the prosecutor addressed the evidence, they doubled down and said, no one said this happened. So it was very unambiguous, and this exceeded ordinary spinning. I'd like to talk also about it was ineffective to not object when the state presented evidence of Haynes being asked why complainant would report false allegations. This was clearly improper because it asked for information beyond Haynes's competence and put him in an untenable position. The Supreme Court in Emmett was concerned about this material rather than the medium of whether it came in through the defendant or through some other witness. It was deficient to let in this self-serving statement without any evidence to back it up, because it opened Haynes up to ridicule in the state's closing argument, lacking any kind of supporting evidence. The state then said that this was outrageous. It labeled this particular statement outrageous. So it was both individually prejudicial, and then cumulatively, with the lack of 23B evidence, it was prejudicial. Also, the destruction of evidence.
And let me ask you a question there.
Sure.
In the reply brief, you spent a number of pages talking about the memories of witnesses being lost. Where was that preserved below? Because I looked at the pretrial and post-trial motions to dismiss, as well as the district court's decision, and the issue of memories being lost was never raised before the trial court. So is it even something that we should be considering in the context of the motion to dismiss?
You should. We did talk about knowledge in the, I believe it's in the post-trial motion, and this.
But that
court
was
has
that was in
recognized-
the Rule of Civil Procedure, Rule 41 portion of the motion. If you look in the actual motion to dismiss for loss or destruction of evidence, memories and all of that doesn't appear anywhere.
There were two different motions, and there was a motion that the trial court ruled on where we argued that the knowledge had been lost as well. And this court has recognized
And
that
where is that
knowledge-
in the record?
I
What
believe
motion
it's
is that?
in the, I want to say in the 1500 area. It was a post-trial motion.
It's separate from the post-trial motion to dismiss? You're telling me there were two of those?
It's in the, there was a pre-trial motion to
Right.
dismiss, and then there was a post-trial motion to dismiss, and I believe
Right.
it was in the post-trial motion to dismiss.
Okay, but you can't point to me where and there it was? Because
All
there were
I can
two
tell-
arguments
I
made.
can tell you, yes, I can tell you that it's in the general 1500 range, but it is there.
Okay, well then let me
And
ask
it
you
was
about
ruled on.
that memories, the trial court decision ruled on the memory issue for loss or destruction of evidence?
I believe they did.
Okay, where is that?
I couldn't tell you offhand.
Okay.
All I can say is it's in the 1500 section. In a sex case, it was also deficient and prejudicial to not.
I actually have more
object.
questions about the memories. So what cases can you point to that a memory that someone had is in the possession of the state and that the state could have lost it?
I'd say look at Red Cap, Your Honor, where they said that knowledge that's in a witness's possession is in fact discoverable. And then I'd say look at Tiedemann, which.
But discoverable isn't possession, right? So for the state to lose or destroy something, they have to possess it. And so if you look at Tiedemann, which is the case that you cite and rely on, in paragraph 40 of Tiedemann, it says that it has to be information in the state's possession.
Well,
So
this-
how is someone's memory in the state's possession?
Specialist was a member of the prosecution team, and she had this knowledge. It was in her possession. She was part of the state, therefore it was in the state's possession. And Tiedemann's concern is fairness to the defendant and the importance of the information and materiality
But
of the
Tiedemann
information
doesn't
overall.
deal with any memories, correct?
No, Tiedemann just says evidence, which would include knowledge.
Well, Tiedemann at issue, though, the issues in Tiedemann were tangible objects, right?
That's
There's no information. So I just want to make sure I understand your argument. Your argument is that because the state knew about the, are we talking about the therapist? Or you're talking about
Therapist,
the,
specialist, and Hardison.
you're talking about all of them?
Yes, that was
Okay.
all in the possession of the state. They
So
had
their
that knowledge.
memories were all in possession of the state, not because
All
their
of their
memories had been, well, what is the information that you're talking about? I understood you to
information
be
was
talking about their
reputation.
memories.
Their knowledge
Okay,
was all
so,
in the possession of the state.
and it was in the possession of the state, how?
Because specialists knew about it in 2010, and then she forgot about it in the intervening decade,
And the state had it in what form?
in the form of specialists' knowledge, which this court has said is evidence.
Okay, so I just want to follow through on this. So if the state becomes aware of an allegation at any point in time and is made aware of a witness who might have information about it, and the investigation doesn't happen at that time for whatever reason. In this case, it's because the victim didn't cooperate. So moving forward at some point in the future, the state does pursue the investigation and move forward from there. If there's any loss of memory, then under your theory, that is a loss or destruction of evidence attributable to the state.
Well, yes, because it's attributable to the state's unilateral decision to wait 10 years between when they had the information and filing charges. So it's the state who should bear the burden of its own decisions.
And that's regardless of the position of the complaining witness or the alleged victim in the case cooperating.
As a matter of fact, that's true. And by 2014, they had a cooperative witness.
Okay, so if we were to follow your theory of loss or destruction of evidence, this would be the first opinion that would actually say that, right, with respect to memories about incidents, because there isn't a case that has so held.
Given Tiedemann's concern for fairness and this court's holding that knowledge is discoverable, it wouldn't be a difficult extrapolation, Your Honor.
But it would be brand new law that we'd be making in this case.
Not terribly. It would be a slight.
So what case would I cite to, or would this
I would
court
cite
cite
to all
to?
three of those. I would say Tiedemann, DeJesus, and Redmond. This was discoverable information, and it was destroyed due to the state's unilateral actions.
And you're saying it was destroyed?
It was, because it was lost to time,
There-
as
there-
we all.
There's a distinction maybe between lost and destroyed. It
Which
certainly
Tiedemann
wasn't
both-
destroyed.
Both of which Tiedemann is concerned with, both lost and destroyed. Tiedemann and DeJesus talked about both lost and destroyed memory. Excuse me, lost and destroyed information.
Seems like if we were to take
Evidence.
the next step that you're encouraging us to, we probably wouldn't say it was destroyed, though, that we would say it was lost.
That would be fair. That would be within what Tiedemann and DeJesus contemplate. I wanted, if I may have a moment, I would like to just say in a sex case, it was deficient and prejudicial to not take a Sharpie to the Just Do Me photo. The state's claim purpose for that would have been equally well served by redacting Just Do Me, and the 2009 photograph didn't show relative sizes in 2007, but I can see that my time is up.
Can I ask you about the 23B motion? Well,
Yes.
At least one part of it before you sit down.
Yes.
The 23B motion, I'm talking about the long affidavit from Mr. Jefferson. He indicates he's talked to a witness named Jessica, and she has some really interesting things to say, including that she says she's willing to, at least she tells the investigator that she's willing to testify that the complaining witness made it all up and was projecting something that happened to her from her boyfriend onto the defendant, that she's also willing to say that the complaining witness had previously falsely accused somebody else of sexual abuse, and that other people, including her own, the person we're calling mother, had a negative opinion of her trustworthiness. And this is potentially sort of explosive evidence, right? And the evidence also indicates that trial counsel talked to this witness before trial. So I guess I'm wondering what you can tell me about that. I'm trying to put myself in trial counsel's situation. He meets with this witness prior to trial. Presumably this witness tells him all or most of these things. And it seems like at that point, you've got to have a really good reason not to call this witness and put her on the stand and talk about the things I've just mentioned. But I guess my question to you is, why shouldn't we assume, based on the ineffective assistance case law that comes down from SCOTUS, why don't we have to assume that counsel did have a really good reason not to call her?
Because this was not a reasonable strategic decision, given the, as you put it, the volcanic impact of this potential evidence. And the record shows that it was not put on in return for the state not presenting evidence that Haynes belonged to the Vagos motorcycle gang, which would have been inadmissible anyway. Given that the record evidence that that was the reason, that was an unreasonable decision, but to the degree that there are still questions, that favors a remand for that to be explored on a 23B remand.
Could there have been other reasons counsel had that we don't know about for not calling this particular witness?
Given that our Supreme Court has specifically rejected the idea that we need to get affidavits from witnesses themselves or from trial counsel, I would say that's a concern to be explored in a 23B remand. As
I would
23B contemplates.
I'd personally be more sympathetic to that if we had in one of the affidavits in front of us that the initial trial counsel had been contacted and was unwilling to provide any information on his or her reasoning for not calling the witness. And then we'd know, well, you did all you could to get information in front of us, but we have no idea to know what trial counsel was thinking without a remand. Was trial counsel contacted here and not willing to speak to his or her thought process?
You know, given the Supreme Court's position on that particular point, they weren't contacted because according to the Supreme Court in Griffin, we do not need that, and that whatever questions there are better explored by the trial court on a 23B remand, because that's the purpose of a 23B remand.
I agree that Griffin says that the witness who would be called on remand doesn't necessarily need to provide the affidavit, but just needs to be identified. But the facts that would come in on 23B need to not be speculative. And with the record as it is in the affidavits, we'd be speculating as to why trial counsel may still have not decided to call this witness.
Well, no, the information that we provided is not speculative. It's not speculative what these people would have said if they were presented.
I agree with that.
With regard to the trial counsel's reasoning, that's not something that 23B requires that we present at this time, and our Supreme Court has said we don't need to present that at this time. In fact, any concerns about that are better explored on a 23B remand, which is what Griffin has said. If there are no further questions,
Okay, thank you, Ms.
thank you
Garland.
very much.
Mr. Gadd?
Michael Gadd for the state of Utah, and may it please the court. I wonder in a case like this where there's more than 30 claims that it might just make sense to take a minute and talk about the evidence that Mr. Haynes is not contesting, because that's the evidence that's going to come up in every counterfactual analysis, every harmless error analysis. So if you'll indulge me for roughly 2 minutes, I think I can outline at least the main points that he's not contending. First, that an 11-year-old girl, Erica, moved in with Mr. Haynes and his wife, who we'll call Mother. It was the first time she had a family, a brother, first time she really had a dad. But less than 2 years later, while she's sitting on a swing set outside the home, Mr. Haynes confides in her that when he was a child, he was molested by a babysitter. And then the very next morning, after Mother's gone, Mr. Haynes comes into Erica's room wearing nothing but a towel, and he orders her into his room and into his bed, where he commits the crimes for which the jury found him guilty beyond a reasonable doubt. Specific to the rape, he used his considerable size advantage to pin her to the bed, so much so that she could barely breathe, and as she cried and as she bit her fist because of the pain, he raped her. And then shortly thereafter, she went to seek consolation from her two best friends, a pair of twins, one of whom testified at trial about Erica's distraught nature when she came over and what Erica had disclosed. And then a few weeks later, the twins and Erica asked the twins' older sister, who also testified at trial, if she could obtain a pregnancy test for Erica. The twins' older sister knew from Erica what had happened. And so even though she wasn't close friends with Erica, she did obtain it. And in this moment of just raw candor in front of the jury, the older sister explains that while she did obtain the pregnancy test, she shoplifted it. And then lastly, I'd point out that mother also testified. And focusing now just on what's not objectionable, according to Mr. Haynes, what this court has in front of it is that mother, after finally being able to talk things through fully with Erica, something that took place years later, but after she finally talks it through for the first time, she immediately goes to a barbecue where Mr. Haynes is present, and she says to him, "Erica said you molested her." And in response, Mr. Haynes turns and silently walks away. None of those facts, none of that compelling evidence
So why don't you
is
start
contested.
why don't you start with some questions right where we left off with Ms. Garland? What the jury didn't hear was this potential witness, we'll call her Jessica for purposes of today, who apparently was willing to take the stand and say that none of that's true. The complaining witness told me that she made it all up and that she was projecting something that happened with her boyfriend onto Haynes, and et cetera, et cetera, et cetera. Shouldn't we remand on 23B on that and let the district court figure out exactly what was going on in counsel's mind here?
No, sir, for many of the reasons that have already been discussed. To remand here, because we don't know what was in counsel's mind and there is no affidavit, even though these affidavits are common. I'd point out in the case that the court heard just a few minutes ago that there was an affidavit there from trial counsel. There's no affidavit here. And although this is not in the record, we've learned today that there was no attempt to even contact trial counsel. This would be a fishing expedition, and the court's never authorized that. However, there are some things in the record that make it very clear why trial counsel reasonably didn't call Ms. Hubbard. So our position today is just assume that the allegations in the affidavit, the secondhand affidavit, by the way, but assume the allegations in the secondhand affidavit are true. There's still a reasonable basis for trial counsel not to put Ms. Hubbard on the stand, despite, or maybe
You're talking about the motorcycle gang stuff?
that's half of it, yes.
What's the other half?
So the other half is just how incredibly impeachable she would be. And I'll tell you, as someone
She
who,
being the new witness?
yeah, Jessica. I'll tell you, as someone who spent a decade as a trial attorney, I'll tell you how I would approach it. It would be with kid gloves, and I would use Erica's statement in the pre-sentence report. There's a paragraph there. I would use that as the basis of my impeachment of Jessica. And the statement is this, that every day of her life, Erica's blaming herself because when she came forward with these allegations, her brother believed them. Her brother is the deceased husband of Jessica. Jessica's a widow whose husband died, according to Erica, because he believed her. And when things took so long before a case was brought, he took it upon himself to go to Mr. Haynes' associates in the Vagos gang to show him, police reports and things like that, to try to convince the Vagos that Mr. Haynes had committed this atrocious conduct. And as a result, had a green light put out on him.
Is any of that in the record?
Yes, in the record.
About the Vargos gang and the deceased brother-in-law's communications with the gang?
Yes.
Is that all in the record?
Yeah, I would take this from the pre-sentence report.
Well, but that didn't come in a trial, so it's not in the trial record. It might be in the sentencing record.
Certainly.
So how can we consider what's in the pre-sentence report if we're talking about evaluating this trial stuff?
Yeah, so the reason I bring that up is to say Erica is the state's main witness. Erica is closely communicating with the state. This came out at trial, right? That she had met several times with the prosecutor to discuss things. There's no reason to think that the prosecutor didn't know all of this or couldn't have easily said to Erica, "Hey, Jessica's on the witness list for the defense. Who is she? What do you know about her?"
Well, and that's what I'm struggling with. Is it seems like the trial counsel might have known some of this stuff, and it seems like the trial counsel, if confronted with a witness who's going to say these things, better have a darn good reason not to call this witness. It seems like potentially explosive evidence. What seems relevant to me here is how much we can assume about what trial counsel knew. If it's just the Vagos stuff, it seems to me like I'm really struggling whether that's reasonable. If all it is the Vagos and you don't really have any other credibility concerns about Jessica, saying, well, I'm not going to put Jessica on to say all these incredibly important things because I'm worried about Vagos, I'm struggling whether I can call that a reasonable strategy. But on the other hand, if counsel's sat down with Jessica, interviewed her, maybe has some of this other evidence in mind, and knows that if he puts Jessica on the stand, Jessica's going to get the crap beat out of her, then maybe it becomes a much more reasonable decision not to call Jessica. But we don't know a lot of that, right? And so
We don't.
what help me understand what sort of thought process we should go through now about that in terms of what we are entitled to assume about what counsel knew versus whether we should just send it back and let these blank spots in the record get filled in. Then it comes back to us and we can assess counsel's motivations a lot more accurately.
I wonder if I could start my response where Your Honor started your question, speaking about the Vagos evidence. The evidence of the Vagos was relevant, and it could have come in for a proper non-character purpose under 404B. However, the parties stipulated. We reached a stipulated order where the state agreed not to put that evidence in because, in the prosecutor's words, this is a gray area of the law. But the prosecutor, made clear that if the defendant opened the door, she was going to walk right through it. The Vagos evidence would be the kiss of death for Mr. Haynes' claims, for his defense. And let me explain why in a non-character way, because I don't want to rely on any propensity, right? But it just makes so much sense when you know it. So as you all know, I came into this case late. I did not brief it. And I had the unusual experience of being able to go first to the trial record and read it as if I was a juror. And I had some questions, as I think a juror probably would. Here's one. So the twins' mother also testified, and she explained that Erica had disclosed to her, but she didn't call the police. And that bothered me. You know, here's an adult who finds out that a child's been raped, but she doesn't call the police. And she sort of tried to own it in her testimony. She said, I don't know if I did the right thing, but this is what I did. And it just didn't sit right with me. But once you know he's a Vagos, it all makes sense. Because in the world in which they live, the twins' mother, Mr. Haynes, snitches get stitches. And you don't call the police. And that's why this woman, this other mother, was so insistent that Erica take that up with your mother, right? We're not going to get involved other than to, try to comfort you. You got to take it up with your mother. That's a proper non-character reason to bring the evidence in, and it just makes so much sense. There's others, we've pointed them out in our brief, including things like, why was Erica so triggered, so traumatized when, as it says in the record, Mr. Haynes and his friends were close by, at a close-by bar, when he was driving his motorcycle in front of the house. Well, that shouldn't trigger or traumatize someone normally, although I don't wish to explain that anyone who's gone through sexual assault can be stereotyped that way. But when you know that it's not just Mr. Haynes, but it's the Vagos, that's a problem, right? Especially in light of what you learn in the pre-sentence report about what happened to her brother, Jessica's husband. There are instances like that throughout the trial where it would have been so incredibly detrimental to Mr. Haynes at trial that his counsel did everything he could, reasonably, competently, did everything he could to keep that evidence out. And he wasn't willing to get close to the line for fear of accidentally crossing over the line and allowing the prosecutor to bring that evidence in.
And it sounds like, and I've not looked at all of the preliminary hearing evidence, but that you would agree that the prosecutor, the defense counsel knew the preliminary hearing evidence as defense counsel was making decisions.
Absolutely.
And could consider that I guess I'm being corrected that we do have evidence about the Vagos gang in the record below, even if it's not the trial portion of that record.
Yeah, and including the 404B motion that was filed. I wonder, I'm happy to talk more about this, but I also want to hit a few of the points that my friend on the other side's made. And this will be a broader point, she's pointed out several times that she considers this a weak case. Several times today, it's replete in the briefs. I want to just take issue with that for a minute. So the nature of child sex offense cases is that there are very infrequently independent witnesses or physical evidence of the crimes. We just don't see a lot of it. But I don't think that the court's precedent shows that all these cases are weak. In fact, these cases fall along a spectrum, right? And there's weak child sex offense cases and strong ones. I'll give you an example on each end, and then I'd like to talk briefly about where we fall. So on the weak end, I'd offer Romero. This is the case, if you'll recall, where the 3-year-old spilled juice on the hardwood floor, and as grandma's cleaning up the juice, Romero goes to clean up the child who spilled it all down in front. And as he walks up, the dog is licking some of the juice, and he says, "Don't let the dog lick your privates." And that, 3 weeks later, that transforms into, "Oh, Romero licked my privates." But at a CJC interview at age 3, no allegation. 2 years later, another CJC interview, no allegation. Case is brought anyway. And at age 7, the child testifies. There was a 609 violation in Romero, but the court spent several paragraphs talking about just how weak the evidence was. And I agree, it was weak. But you take on the other side of the spectrum, a case like Nunez. This is, you'll remember this one. This is a 15-year-old who was raped by her boyfriend. And kind of the unusual part of it is, as he's holding her down and raping her, he's reciting satanic chants. In this case, Nunez is all about consent. It really comes down to just consent. So there's no independent eyewitness of whether or not she consented. There's no physical evidence that will tell you whether or not she consented. It is, in Mr. Haynes' view, it's a weak case. But in reality, the evidence there is strong. And even though that's a bolstering case where a mother improperly bolstered, the court affirmed.
What you're saying goes to prejudice on each of these IAC claims, but I want to ask, setting prejudice aside, explain why it's not deficient performance to have redacted the "just do me" from the T-shirt and the photo.
Yeah, so could a reasonable trial counsel have not wanted to redact it, or as my friend on the other side has said, take a Sharpie to it? And to that I would say, of course, because the devil you know is sometimes better than the devil you don't. And when you redact things, you are planting this idea in the mind of the jury that there was something really bad there. And you look at the language, and it's not something I would choose to wear, but it's not all that bad either. And I think you have to define it pretty broadly before you even consider it to be bad. On its terms, it shows a passiveness, not the type of extreme aggression that you would expect from a child rapist. So no, I think reasonable counsel could prefer to show Mr. Haynes in the light that he was, rather than risk having the jurors' minds and their imaginations conjure up something worse.
Can you talk about the bolstering by mom, about how mom indicated that initially she didn't believe the complaining witness, but 4 years later, based on some change in circumstances, she did, and respond to counsel's argument that that's just not allowable under the rules?
Yeah, I wonder if I could start first on prejudice there and return our discussion to this idea of the case Nunez, because this is the closest case to being on point. So as I've read the court's case law, and I think I read 90 cases to get ready for today because I'm new, right? But as I've read the case law, I saw a split in how the court approaches these bolstering cases. And the split runs along the lines of the type of person who's doing the bolstering. So you take cases like Seegers and Iorg, Haffer Burnett, Bishop Garcia, and those are all professionals or experts or police officers who did the bolstering, and those cases all get reversed. But then you have cases like Nunez, and I'd add to that King, where you get a close family member. In Nunez, it's a mother. So the mother went to counseling with her victim daughter and then was later on the stand and asked, when you were at the counseling, when your daughter was disclosing all of this, did you think she was faking? And the mother said, well, no, of course not. And the court in Nunez, said, okay, yes, that's impermissible bolstering, but there's no prejudice here. Because what juror didn't expect the mother to say that she believed her daughter?
Yeah, okay, but here the mother initially didn't believe the daughter.
And then changed like we would expect. And I understand that there is that slight difference, but the mother believed her daughter once she heard her out for the very first time. So in a very real way, we're just right back in this Nunez category. King is very similar, other than it's not a mother, it's a grandmother. there's a schism in the cases, and that's where the court's drawn the line previously. I think it's where the court should draw the line here.
Mother ends up talking about, and the victim ends up talking about the kissing that happened after the rape. I don't see that falls under 404C because by that time she was older than 14. Do you agree with that?
I think it's better analyzed under 404B. I do.
Thank you.
I think it comes in under 404B, however.
So in response to my question about Mom's, I didn't believe her and then I did, you went right to prejudice. Are you conceding that was deficient performance?
I think under Nunez, I'd probably have to concede that it's the type of statement that shouldn't be offered, especially directly elicited as bolstering. That was the problem in Bishop Garcia, right? Is that it was purposeful, it was elicited bolstering. Here, there's some good arguments that that's not at all why this question was asked, right? And I think the court pointed this out, that what's really happening here is we're trying to bring the story up to a point where the jury can understand how a woman who initially wouldn't even listen to the allegations and wouldn't talk to Erica for some years is now at a point in her life where she will walk into that barbecue and immediately go to Mr. Haynes and say, Erica said you molested her. And I think there's a proper way to do that. I wish the testimony would have come out just slightly different, but regardless, I'm willing to rest on prejudice there because I don't believe there is any.
Okay. Any additional questions from the panel?
Thank you.
Okay, thank you, Mr. Gadd. Back to you, Ms. Garland, for rebuttal.
Thank you, Your Honor. The state said that maybe I didn't understand correctly, but I think they said that we didn't contest the crime, and in fact, Haynes did. He contested, he denied all sexual behavior, and that was in the record, with sexual behavior with the complainant, and that was in the record, and the jury heard that. That was what he told the detective. With regard to the other evidence, that all makes up a case like other cases that this court and our Supreme Court has said is not strongly supported by the record. The text, moving also to 23B, the text of 23B does not require that I obtain affidavits from other lawyers, and in fact, our Supreme Court has rejected that is a requirement. I'd like to push back on the idea that the 23B witnesses that we spoke to were not credible. The state argued below that somebody who's able to give a lot of detail is credible, and our 23B witnesses gave very detailed statements, which is in our 23B motion. The state has said that the Vagos information would have been really terrible for it to come out. It would have been inadmissible, first because it was irrelevant to the crime.
So let me ask you about the Vagos information. So why did trial counsel fight so hard to keep it out? Because you've said it's basically worthless. It's never coming in under any circumstance. So then why is defense counsel making all of these efforts, filing motions to specifically keep all of this evidence out and getting the state to stipulate to keep the evidence out? So success in the trial court before trial to keep it out. It just begs the question, why? If it's so inadmissible, why does counsel even bother doing that?
Well, it makes sense that he would try to keep it out where it's inadmissible. I mean, we do file motions in trial court to keep inadmissible evidence out.
Right, but he was successful in convincing the state that they ought to stipulate to keep it out. So if it's so inadmissible, why doesn't the state say, yeah, file whatever motion you want, we'll take it up with the judge because this is it's so inadmissible.
My recollection is that the state said on the record at the motion hearing that it lacked a proper non-character purpose, and so the trial lawyer was correct about that. As far as not putting on this witness because of that was an unreasonable conclusion because this was inadmissible evidence anyway. But if
It seems like it
may,
maybe there's a good argument that it's inadmissible on a blank slate, that you were in a gang, that makes you look bad. But that once you put on a witness who starts testifying as to why someone might have lied or that someone did lie on a particular occasion, and I'm not well versed enough in the evidence to get real specific on the questions that might be asked, but it does seem like once you put that witness on the stand, there is a high likelihood that you are going to open the door and make that gang evidence relevant in ways that Mr. Gadd explained, that are not just for a character purpose.
If this was some kind of a rape gang, then I think you would be, you could be correct, but lacking any evidence to that point, I would say no, it was completely irrelevant. There's no evidence in the record that supports any of that. And it's not appropriate to consider hearsay from the pre-sentence report. My other point was that the Just Do Me slogan suggested a reckless, sexually aggressive character, which was prejudicial in a sex case where the prosecutor talked about Haynes's character. The state has said too that that this case was strongly supported. State versus Burnett was a child sex case in which this court said that cases lacking confession, eyewitness, or physical evidence are not strongly supported. Thank you.
Thank you, Ms. Garland. Thank you, Mr. Gadd. We appreciate the arguments that you've both made today and helped us understand this case a lot better. We'll take this matter under advisement and we'll get a decision out to you as soon as we're reasonably able to do so. Thank you, and with that, the court's adjourned.